Skidmore, Missouri has fewer than 500 residents in 1981. It is rural. Isolated. The kind of place where everyone knows each other's history. On July 10, 1981, in the center of town, a man is shot in broad daylight in front of dozens of witnesses. No one is ever convicted. If stories like this matter to you, consider subscribing, because what happens next reveals how this system truly works. The man is Ken McElroy. He is 47 years old. 4 years, he is accused of theft, intimidation, assault, and statutory rape. Many charges never lead to prison time. Witnesses often refuse to testify. Some later say they are afraid. McElroy lives just outside town with his wife, Trenor. Prosecutors charge him multiple times in the 1970s. Cases collapse. Witnesses recant. Homes and property connected to people who testify against him are burned or vandalized. No convictions stick long enough to remove him permanently from the community. In 1980, he is convicted of shooting a local grocer, Ernest Bowenkamp, during a dispute. The conviction carries a prison sentence. He is released on bond pending appeal. He returns to Skidmore. Residents say tensions increase. On the morning of July 10, townspeople gather at the American Legion Hall. They discuss what to do about McElroy. The local sheriff, Dan Estes, is present earlier in the meeting. He leaves before it ends. Accounts vary on what is said. What is documented is this. Shortly after the meeting, a group walks toward the D&G Tavern where McElroy sits in his pickup truck with his wife. Shots are fired. McElroy is struck and killed. He dies in the driver's seat. His wife is beside him. Dozens of people are nearby. No one claims to see who pulls the trigger. Investigators arrive. The Missouri State Highway Patrol leads the case. Witnesses are interviewed. Most say they hear shots but do not see the shooter. Some decline to cooperate. No one identifies a suspect. No weapon is recovered that leads to charges. A county grand jury convenes. It does not return indictments. The case remains open but inactive. The killing becomes one of the most unusual unresolved homicides in modern American history. Skidmore does not speak publicly about what happens. Journalists report a pattern of silence. Residents describe years of fear before the shooting. Law enforcement records show repeated arrests and dismissed charges. Yet in court, allegations are not the same as convictions. McElroy spends little time in prison during his life. Despite numerous accusations, the system does not secure long-term incarceration. Witness intimidation is alleged but difficult to prove. Rural prosecutions depend heavily on local testimony. When witnesses refuse to cooperate, cases weaken. After the shooting, no one is arrested. Prosecutors cite lack of evidence. Without eyewitness identification or physical evidence tying a suspect to the crime, charges cannot stand. The standard remains proof beyond a reasonable doubt. National media covers the story. Some describe it as vigilantism. Others focus on systemic failure. Legal experts note that collective silence complicates prosecution. The Fifth Amendment protects against self-incrimination. Without cooperation, investigators face limits. For the prison system, the case highlights a different issue. McElroy is repeatedly charged but rarely confined for long. Appeals and bond release allow him to return home. Pretrial release is a constitutional right in many circumstances. Bail is not a conviction. Residents later say they feel abandoned by the justice system. Court records show procedural delays, overturned convictions, and appeals. None of these equal innocence or guilt. They reflect process. The Bowenkamp shooting conviction is under appeal at the time of McElroy's death. Had it been upheld, he could have served significant time in state prison. Instead, he remains free when he is killed. The town moves forward. Businesses reopen the next day. No arrests follow. The official case file remains unsolved. Law enforcement officials continue to state that without witnesses willing to testify, prosecution is impossible. The silence holds. The murder of Ken McElroy remains open. No one serves time for his death. No jury hears evidence. No prison sentence is imposed. The justice system depends on cooperation, evidence, and testimony. In Skidmore, on that July morning, those elements disappear. Investigators from the Missouri State Highway Patrol remain in Skidmore for weeks. They canvass homes. They re-interview witnesses. Reports confirm that between 30 and 40 people are present near the scene. Many acknowledge being within sight of the truck. None identify a shooter. Several state they hear 2 gunshots. No one claims to see a weapon clearly. A .22 caliber rifle is believed to be used. Ballistics analysis confirms the type of ammunition. The weapon itself is never definitively tied to a suspect in court. Without a cooperating witness or a recovered firearm linked through forensic testing, prosecutors lack probable cause for arrest. A Nottoway County grand jury convenes later in 1981. Witnesses are called under oath. Testimony is sealed. The grand jury declines to issue indictments. Officials publicly state that the standard for criminal charges is not met. The case remains open but dormant. National outlets report on what some describe as a community unwilling to speak. Legal scholars note that silence is not itself a crime. The Fifth Amendment protects individuals from compelled self-incrimination. Refusing to identify a shooter, absent perjury, does not automatically constitute obstruction. For the American prison system, the absence of charges means absence of incarceration. No suspect enters a jail cell. No pretrial detention occurs. No plea agreements are negotiated. The machinery of prosecution stops before it begins. The case also draws attention to rural law enforcement limitations. Small departments rely on cooperation from residents. When that cooperation disappears, investigative capacity narrows. Unlike large metropolitan agencies, resources are limited. Specialized forensic tools in 1981 are fewer than today. DNA testing is not yet available as a standard investigative method. Ken McElroy's prior convictions and arrests are documented in court records. Yet those records do not determine responsibility for his death. In American criminal law, prior behavior cannot substitute for proof of a current offense. Each case requires independent evidence. Civil remedies are also limited. No wrongful death lawsuit produces accountability tied to a specific defendant. Without a named individual responsible, civil liability struggles to proceed. The legal system depends on identification. Over time, the town's population declines. Skidmore remains small. Journalists return periodically on anniversaries of the shooting. Residents often decline interviews. Some express fatigue. Others reiterate that the past is closed. The murder becomes part of criminal justice discussions in universities and law schools. It is cited as an example of collective non-cooperation. It is also cited as a warning about gaps between community fear and courtroom standards. The prison system is designed to confine individuals after conviction. It cannot function on suspicion or rumor. In Skidmore, no conviction follows. Therefore, no sentence is imposed. The state cannot incarcerate without proof beyond a reasonable doubt. Sheriff Dan Estes later states publicly that solving the case would require someone to come forward. No one does. The statute of limitations does not apply to murder in Missouri. Legally, charges could still be filed if evidence emerges. Decades pass without that evidence. The absence of prison time in this case contrasts with the numerous allegations that precede the killing. It underscores a structural reality. Courts require testimony. Juries require evidence. When fear or loyalty prevents testimony, prosecution weakens. Ken McElroy is buried in Memorial Park Cemetery in Skidmore. His death certificate lists gunshot wounds as the cause of death. Officially, the homicide remains unsolved. In many prison documentaries, the story ends with sentencing. In this case, there is no sentencing phase. There is no transfer to a correctional facility. There is no intake photo or inmate number connected to the shooting. Instead, there is a closed circle of witnesses and an open case file. The American justice system is built on procedure. Arrest. Charge. Trial. Conviction. Sentence. In Skidmore on July 10, 1981, that sequence breaks after the first step. The file remains archived but active. No one serves time. No one stands trial. The silence of the town continues to define the case. As years pass, the shooting in Skidmore becomes a reference point in discussions about community justice and the limits of formal prosecution. Law enforcement officials periodically review the file. They confirm that without new testimony or physical evidence, the case cannot move forward. The evidentiary threshold for arrest remains unchanged. Missouri law treats homicide as a crime without a statute of limitations. In theory, charges can still be filed. In practice, cases grow more difficult over time. Memories fade. Potential witnesses die. Physical evidence degrades. The absence of early cooperation compounds these barriers. The prison system reflects outcomes, not suspicions. In this case, there is no defendant process through booking. No bail hearing follows. No pretrial detention occurs in a county jail. No transfer to a state correctional facility is recorded. The system stands ready, but it is never activated. Legal analysts often compare the McElroy killing to other instances of alleged vigilantism. The distinction is procedural. Vigilantism implies identifiable actors. In Skidmore, the absence of identification prevents that classification in court. Without a named offender, the legal label remains simply unsolved homicide. The broader criminal history associated with Ken McElroy is documented in court archives. Arrest records show repeated charges including assault and theft. Convictions are limited and frequently appealed. Bond release allows him to remain free pending review. These mechanisms are part of constitutional design. Appeals and bond are safeguards against wrongful conviction. For residents who later speak publicly, frustration centers on perceived systemic failure. Yet frustration does not alter burden of proof. American criminal courts require unanimity in jury verdicts for felony convictions. They require admissible evidence. They require testimony subject to cross-examination. None of these elements materialize after the shooting. The case is studied in criminal justice programs as an example of collective silence. Scholars examine whether social pressure can effectively shield individuals from prosecution. They note that silence alone does not equal conspiracy. Prosecutors must demonstrate agreement and participation to pursue conspiracy charges. Such proof does not surface. Media attention declines over the decades. Occasional documentaries revisit the town. Reporters describe Skidmore as cautious with outsiders. Some residents maintain that speaking publicly only reopens divisions. Others state simply that they did not see who fired the shots. The justice system does not convict communities. It convicts individuals. In the absence of an identifiable defendant, the state cannot proceed. The presumption of innocence applies universally, even when suspicion circulates informally. Within correctional institutions across the United States, inmates serve sentences imposed after trial or plea. Intake procedures classify them. Records track their custody level. None of these processes attach to the McElroy homicide. The prison population does not include a person convicted of that crime. The file remains a reminder of structural limits. Law enforcement authority depends on cooperation. Prosecutorial power depends on evidence. Courts depend on testimony. When each link weakens, incarceration does not occur. Skidmore continues as a small rural town. The shooting remains part of its recorded history. Official statements from authorities are consistent. The investigation is open, but no charges are pending. The absence of imprisonment in this case is not an endorsement of violence. It is a reflection of procedural boundaries. The American legal system is designed to prevent punishment without proof. In Skidmore, proof sufficient for court never emerges. Time changes the landscape of Skidmore, but it does not close the case. Decades pass. The homicide of Ken McElroy remains officially unsolved. Law enforcement agencies periodically confirm that the investigation is still open. No new indictments are issued. No arrests are announced. The physical evidence collected in 1981 is preserved according to the standards of the time. Advances in forensic science transform criminal investigations in later years, particularly the development of DNA profiling. In this case, there is no biological evidence publicly identified that links a specific individual to the shooting. Ballistics alone does not produce a prosecutable suspect. Grand jury secrecy laws prevent disclosure of detailed testimony given in 1981. What is known is procedural. Witnesses are called. Questions are asked under oath. The grand jury declines to indict. Without indictment, there is no criminal trial. Without trial, there is no conviction. Without conviction, there is no prison sentence. The American prison system operates downstream from these decisions. It receives individuals only after due process is completed. Correctional facilities are not investigative bodies. They are custodial institutions. In the McElroy case, the process never reaches that stage. Legal scholars continue to cite the killing as a rare example of a public homicide without cooperative witnesses. The case illustrates the limits of state power when evidence is unavailable. It also illustrates the protections embedded in constitutional law. The presumption of innocence applies even when suspicion circulates widely. For the residents of Skidmore, the event becomes part of local memory. Some who are present in 1981 later pass away. Others relocate. Population numbers fluctuate. The American Legion Hall still stands. The site of the shooting remains an ordinary part of town geography. No civil judgment assigns financial liability tied to a proven shooter. No criminal record reflects conviction for the homicide. Official databases list the case as open. The Missouri State Highway Patrol reiterates that credible new information could revive active prosecution. The structure of American justice emphasizes individual accountability. Collective silence does not equate to collective guilt in court. Prosecutors must identify a person, present admissible evidence, and persuade a jury beyond a reasonable doubt. These requirements are barriers by design. The prison system often appears as the final chapter in crime narratives. Intake photos, sentencing hearings, parole reviews. In Skidmore, those chapters do not exist. There is no mugshot connected to the homicide. No inmate file. No disciplinary record inside a correctional facility. The absence of incarceration does not resolve the underlying tensions that precede the shooting. Court archives continue to reflect McElroy's prior arrests and limited convictions. They also reflect appeals and procedural safeguards. The same safeguards that protect defendants before conviction prevent punishment after his death without proof against another. The case remains a study in contrasts. Allegations over many years. A public killing in daylight. Dozens of potential witnesses. 0 convictions. It demonstrates both the vulnerability and the restraint of the legal system. In the United States, punishment without proof is prohibited. That principle holds even in cases that generate national attention. The rule of law demands evidence. When evidence fails to meet required standards, imprisonment does not follow. More than 4 decades later, the file remains open. The town remains small. The homicide remains unresolved. The prison system remains untouched by this particular crime.